Thank you very much again to our in-person participant here in Geneva and to the online participants. As you can see, I have now been joined by the rest of the panel. Thank you very much for your patience and apologies for the slight delay. As you can imagine, the Human Rights Council is always an extremely busy season, so it explains the slight delay. My name is Cyprien Fluzin. I will act as a moderator today. I'm a PhD researcher here at the Graduate Institute in Geneva and at the Geneva Academy, and I will introduce our panelists very shortly. But first of all, thank you very much again for joining us again in person here in Geneva or online. I know that we have participants from many different countries and many different backgrounds. So we're really excited to have you, and we hope that it will be a very interesting conversation today, again, here in the room and with all of you online. So this event, as you all know, is on repatriation, repatriating foreign fighters, upholding peace and human rights. And we'll be discussing state's obligation and state and shared responsibility towards foreign fighters and their family members detained in Syria, or those who are being repatriated. With me today, a very fantastic panel to discuss this issue. Obviously, the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, Fionnuala, which I don't think I need to introduce, but I will very briefly. You're Professor of Law, Public Policy and Society at the University of Minnesota Law School, and also at the same time Professor of Law at the Queen's University in Belfast. You've previously taught or held visiting positions at Harvard Law School, Columbia, Princeton, and the Hebrew University of Jerusalem. But we all know you in this role as Special Rapporteur and for all the work you have been conducting over the past several years on the issue of foreign fighters in particular. With the UN Special Rapporteur, we have Dr. Khalid Koser. You are the founding executive director of the Global Community Engagement and Resilience Fund, which has an international organization that has sometimes been called the Counter-Terrorism, Counter-Extremism Bank, I believe, which was created by a number of state donors concerned with the issue of extremism and willing to take action and to encourage local actors in particular to work on countering extremism. You are Professor of Conflict, Peace and Security at the University of Maastricht, and you're also a non-resident fellow at the Law Institute, and you were previously a fellow at Chatham House as well. You have also significant expertise on the issues of migration and refugees. So thank you very much for being with us today, and we look forward to hearing from you and from your experience and your expertise. And finally, Cholpon Orozobekova, who is a conflict analyst and terrorism expert, and also the director of the Bulan Institute for Peace Innovations, who is the co-organizer of this event. Cholpon has an extensive career, 17 years in international media, and you have published a number of media back home and in the world. You recently published a book called Foreign Fighters and International Peace that I have here with me, where you discuss the issue of foreign fighters traveling there and also returning, especially from the perspective of Central Asia, which you are really familiar with. And you are currently, as I said, the director of the Bulan Institute, where you conduct a number of research on the issue of foreign fighters, repatriation, and so on. And I think many of our participants have access to some of the publications that Bulan Institute has put online, very interesting indeed on this topic. I won't take any more time because I think most of us here are familiar already with the issues arising from the situation of foreign fighters. I think most of us are familiar with the phenomenon. We are familiar with the figures as well. We're still talking about thousands of people, women, children detained in camps in northeast Syria, as well as men and boys, which we'll also be discussing today, mostly imprisoned as well by the local authority in northeast Syria. Over the past couple of years, the debate has been over whether or not to repatriate those individuals for their states of origin, with many states being reluctant to repatriate their citizens. Within the humanitarian community, the human rights community, or the security community, national security community as well, there is, however, consensus that those individuals should be repatriated, and that is the only long-term solution that is in line with international law, but also practically and from a policy perspective, the best solution. So this is what we will be discussing today. We will be discussing some legal aspects, some humanitarian aspects, political aspects, but also practical. And again, we'll be relying here on Khalid Koser's experience in particular, but also Cholpon in that respect. Without further ado, I will give the floor to the UN Special Rapporteur to give us a bit more background, tell us a little more about the situation there and also your experience over the past years discussing the issue with actors on the ground, with governments, with humanitarian actors, and tell us also a little bit about the legal framework in which this issue is occurring and what you take on the legal challenges or lack of challenges from a legal perspective. And so we're really, again, happy to have you. Thank you so much for joining us.
Great. Thank you all, and I greatly appreciate your patience. Mandate was engaged in another event that ran late at the Palais, so apologies for holding you to our start. I want to start by acknowledging my co-panelists, in particular, thanks Cholpon for all her tireless work on this particular issue. The Bulan Institute has been really one of the places where we're seeing an enormous accumulation of knowledge, a deep engagement with practice on the ground, as well as both a sort of pragmatic and principled approach to addressing the repatriation of foreign nationals and a resolution to the situation in northeast Syria. I think it's worth saying that in making these remarks, I want to focus on maybe what we might call the hardest outstanding issues, recognizing that many of the actors that have been recognized have been working on the issue of return or repatriation of foreign nationals and other nationals from the camps in Aoláin and the multiple other camps in the jurisdiction of northeast Syria. Have generally, in many ways, moved the needle over the past couple of years. When I started as Special Rapporteur, actually there was very little movement, political movement on this issue. Blanket generally response by states of non-return, an unwillingness to address the complexities of the issues, and a sense that it would be very, very difficult to get any movement at all on repatriation. And I think we've certainly moved from that. So it's worth reflecting on where we are now, where we've come from, but also the really difficult task that lies ahead. So I think it's important, we do have numbers, but I actually do want to start by breaking down the numbers, because the numbers actually tell us something about the scale of the problem and where the really hard spots lie in the discussion. So our estimate, the mandate's estimate, is that there are still around 65,000 foreign and Syrian men, women, and children detained in northeast Syria. 23,000 of those are Syrian, and 42,000 of those individuals are foreign nationals, of which approximately 15,000 are third country nationals. In the two largest locked camps, and I think it's important for me as Special Rapporteur to underscore, this is a situation of mass arbitrary detention. Any nomenclature that suggests people are residents, they're by willingness refugees. This is incorrect as a legal matter. These are camps in which people are arbitrarily detained. In the two largest camps for women, girls, and young boys, Al-Hol and Al-Raj, they hold approximately 37,000 foreign nationals, of which 27,000 are Iraqis and 10,000 are third country nationals from approximately 57 countries. In both of these camps, the vast majority of the population, over 60%, are children. And 80% of that 60% are children under the age of 12, and 30% are under the age of 5. So actually, we're talking about mass arbitrary detention of extraordinary number of children. So when we think of the kind of language that's used to describe who's in the camp, the word child frequently gets forgotten, as does the obligations of states in relation to children. Another point worth noting, and I think it's one that the mandate has not focused on, but it's come into sharp focus for us in recent months, is that it's worth observing that in the neighboring state of Turkey, for example, there's another sizable population of third country nationals who fled the territory of Syria and some from Iraq during the conflict or in the end of the Islamic State. And so we have a large and sizable number of third country nationals who are in other territories adjacent, some of whom are completing jail sentences, many of whom are living in the shadows, and none of them, frankly, have a clear legal position in the countries in which they are currently found. So it's also clear that this population, which has generally not been considered as part of the population we need to think about in the context of repatriation, is a population that has been under appreciated and under addressed in terms of both issues of return, issues of non-refoulement, as well as the issues of the current regulation of their situation, many of which, again, have no clear legal status, many of whom are subject to surveillance, some of whom are in prison. So it's important when we say that there's been movement, and I think as Special Rapporteur, I would acknowledge that there's been movement in repatriation. We still have extraordinarily high numbers of individuals arbitrarily detained in these camps. So it's important to say, for these people, there is no legal basis for their blanket indefinite detention. All of these individuals, most of them children, have been detained without judicial authorization. There's no review or control or oversight of their detention. And this is clearly arbitrary detention under international law. It lacks predictability. There is no rule of law to apply here. And it's important to say, while there's a primary actor visible for the purposes of their detention, there are also many other actors engaged in the facilitation, enablement of their detention, including through the building of the prisons and the facilities in which they are maintained. So a lot of stakeholders, mostly states, have argued that these individuals have to be detained because they pose a security threat. It's interesting to me as Special Rapporteur that we think of the scale of children in detention under the age of 12, and we talk about security threat. It's important then to say that the perceived or actual affiliation with Daesh, as this narrative goes, makes return, resettlement, or letting people go just too risky. And again, we're talking primarily about a population which is made up of children. So I want to say something about threat and threat assessment, because that seems to be the terms in which many states want to conduct the conversation. And it is to say, and it's a matter I have addressed in the report I issued to the Human Rights Council this week, is that when we think about threat in these narrow ways, threat which is vacated from an understanding of the entrenched, sustained human rights violations that are part and parcel of this situation, our assessment of threat is actually entirely partial and inadequate, because human rights violations, systemic human rights violations, are also the conditions that continue to produce and sustain threat. So threat assessments that fail to take account of the human rights, of the human securities that are implicit in this detention context, the costs of entrenched violations to rights of the child, are really missing something about the production of violence and the ways in which a really narrow understanding of security misses a broader point about human security and threat measured in a more holistic way. But things are, in many ways, they're changing for a couple of reasons. Well, one, and I won't say more than to acknowledge that we've had a number of court decisions that really change the landscape for member states. One of those is the European Court of Human Rights, a case involving France, which the mandate was a party to as amicus. And the court found that the situation in the camps verges, quote, on a legal vacuum. It's very clear that the court found that the conditions in the camp constituted threats to the lives and physical well-being of those who live there. If we look at national jurisdictions, probably one of the most infamous cases is the Shamima Begum case, a young woman who the Standing Special Immigration Appeals Commission found, and again, I should say the mandate was party to these proceedings as amicus when this case went to the Supreme Court in the United Kingdom, found that, quote, the conditions in the camps are so bad that they meet the threshold of inhuman and degrading treatment for the purposes of Article 3 of the European Convention. The Committee on Torture has found similarly, and the Committee on the Rights of the Child. So there's an emerging legal consensus that states who are bound by these obligations are forced to contend with, which is that the conditions their nationals are held in and their responsibility for them, that the conditions meet these thresholds. There's also a really interesting case that's just emerged from the federal courts in Canada. Again, a case in which we were a party as we submitted evidence to the court in the context of those proceedings, which found that Canada has a legal obligation to return the men who are detained in the prisons. Not based in, there's a recognition of international law, but actually the decision is mostly about the Canadian Constitution, the right of free movement and the obligations of protection under the Canadian court. So we have this emerging legal consensus. So it's really interesting that telling states that they should repatriate before courts tell them that they have to bring back everybody would seem to be a kind of a smart move, right? But we've seen a huge hesitancy by states to actually, and maybe the decision in the Canadian court will, I think, crystallize the point that courts are going to make decisions for you if you don't make decisions before the courts get to these cases. And there are cases emerging in many different contexts. And it's also, just to say the obvious, and I know maybe Cholpon and others, but I just want to stress from the mandate's position, we've communicated extensively on this issue. There are 57 letters to the 57 countries, and my senior legal advisor, Dr. Anne Chabert, is here, and Anne has led the work of the mandate on this issue. And we have communicated with every single state and found that the conditions in the camp constitute torture, inhuman and degrading treatment under international law, that they are under a legal obligation and have what we believe to be a significant degree of control over the lives of the persons who live in the camps, that they exercise a form of jurisdiction that mandates they operationalize return. We've also been very clear that there are issues of trafficking and grooming for a number of these individuals. Shamima Begum's decision also confirms effectively the fact that there was a failure in the obligation to protect a vulnerable child from travel, and instead she ends up in a camp before the age of 18, pregnant 3 times, and loses all 3 of her children, and is then stripped of her citizenship in a context where she is a victim of trafficking, likely and grooming online. And again, just to say, if you leave aside the discussion of the camps here, the idea that we would so disintegrate the quality of protection for victims of trafficking because states are so narrowly focused on ensuring that these certain individuals don't get back from the camps speaks to the broader legal and political consequences of the kinds of positions that states have taken. I will say, and we all know it, that the situation in northeast Syria is politically fluid. The risks of it to the camp, as evidenced by the breakout in Al-Hasaka camp last year, demonstrate that even if we weren't to have the word human rights in the conversation at all, it is simply unsustainable to be engaged in mass arbitrary detention over the long term. So I want to say we've definitely made some movement, and I know Cholpon is going to talk about this in relation probably to the countries that she has worked most closely with, but there are some categories where we're making zero movement. And the category we're seeing almost no movement on is men and boys. So we've seen an unwillingness of states to even countenance the idea of return. We've measured, the mandate finds that since 2019, we've had 36 countries accept the return of approximately 6,500 of their citizens. We've seen repatriations pick up in the last year. So we've seen countries like Australia, Australia had 17, Anne? Yes, 17. 3 to Barbados, 102 to France, 12 to Germany, 59 to Kyrgyzstan, 40 to the Netherlands, 38 to Russia, 2 to the United Kingdom, 3 to Spain, and just over 2,500 to Iraq. So there's movement, but it's clearly not enough. I mean, this is a drop in the ocean. When we go back to the numbers we started with, we're actually not moving the larger scale issues more. But it's important to say that the number of countries doing repatriation, there's a large number of countries not doing any at all, that need to be doing it urgently given the number of nationals in the camp. But it's also clear that there are categories, if we think of in particular men and adolescent boys, who are effectively being deemed non-returnable by the kind of rhetoric and language that's being used about them. So we see men and adolescent boys being portrayed as the quote worst of the worst. They're the language of terrorist fighters being applied to boys as young as 10, 11, 12 years old. The framing of jihadis in the context where, like, remember, there's been no legal process. So if that is not painting with a broad brush, what we have is a rhetoric that chooses to treat all of these individuals effectively as subhuman, no matter if they're a child or an adult. And of course, if you're in that category, you'll never be worthy of repatriation to your home country. It's important to note that many of the detentions in the mandate's view are being carried out at the behest of the countries of nationality. The SDF has indicated it would like to have these people leave, but many of these states clearly want their nationals held onto. We see the building of a new high security prison to replace the one that was destroyed in Hasaka. It's called Panorama. We've seen several so-called rehabilitation centers that, again, the mandate's view in multiple communications, these are not rehabilitation centers. These are prisons, warehousing primarily young boys with no due process. And there's no sense that we're moving away. In fact, states are paying and spending a lot of money to entrench a model of mass arbitrary detention. And that should worry us all. I want to highlight 2 things before I close. One is the practice that we're seeing in relation to boys. The separation of young boys from their mothers arbitrarily based on their age and their sex is extremely concerning to my mandate. We see no legal basis being presented for that separation, no process, and frankly, it is entirely inconsistent with the Convention of the Rights of the Child. There's, in many ways, we might think of some of these seizures of children as enforced disappearances because their mothers don't know where they are, have very little information about them. And so all of that is deeply worrying. The second category I just want to close on is many of us have said these individuals have to be returned. But many of these individuals, in fact, can't be returned to their countries of origin or nationality because of non-refoulement concerns. They will face a threat to their lives or a threat of harm if they are returned. So one of the problems we have is that when we have a sizable population, the extent to which we just don't know, because actually there's never been an exercise of identifying who precisely is in the camp formally and what they have done or where they are from, and we can't return home. And so that begs another set of really complicated questions, which is, what are you going to do with them? If nationals are not taking home their own, are they likely to want to take someone who's a non-refoulement person for the purposes of repatriation? And so let me close by saying we have layers of obvious problems, but we also have layers that we haven't quite yet unpacked in the situation of detention, which deal with those who are male and those who can't be returned. And I'll close there and welcome comments. And thank you.
Thank you so much. And indeed, so very interesting overview and picture you gave us of the situation. And from a legal perspective, and I think we have a number of colleagues here who are working on the legal aspects of the issue, it's definitely a cocktail of a number of legal challenges and legal instruments that apply, or some argue don't apply, but you've mentioned enforced disappearance, inhuman degrading treatment, non-refoulement, arbitrary detention, obviously, and then all the issues of jurisdiction that are also attached to all of this. So this is maybe something that we'll also go back to briefly in the questions. But now I'd like to move to Cholpon, and Cholpon, maybe hear a little bit about your experience and your approach to this very issue as well, and especially with your knowledge of Central Asia and what you have seen in also meeting with and discussing with women and children. So what can you tell us a bit more on this?
Thank you very much. First of all, I would like to thank Her Excellency Fionnuala and Aoláin for joining us, and thank you for your important work, essential work on the issue. And thank you, Mr. Khalid Koser, for joining us. I know that your is doing really excellent work on the ground. So without your support, I think rehabilitation and reintegration programs on the ground wouldn't be possible. And regarding the Bulan Institute, so when ISIS was defeated, the main question was what to do with how to deal with the current situation, the given situation with the family members, thousands of women and children, and male fighters also. And we started looking at the approaches of states, reaction of states, and then our focus countries are in the Central Asia as well. And then Kazakhstan and Uzbekistan repatriated first. And then we said, okay, we need to observe, we need to research, and we started working on the issue. So we had access to the region, and we started studying. So what will happen to them when they will return to the country? So in Uzbekistan and Kazakhstan, I think, so first of all, I will give you some numbers. Kazakhstan repatriated 722 women and children, including 37 men. Uzbekistan repatriated 535 women and children. So I think Uzbekistan and Kazakhstan somehow were lucky at the beginning because they had full support of donors, United States. And I would like to tell you that rehabilitation and integration programs should be very long-term, and they demand really high financial resources and human resources as well. But Uzbekistan and Kazakhstan really built comprehensive programs to rehabilitate women and children. So what happened to them? They arrived in the country, and then first they spent several months in the adaptation centers. And then they received all kinds of support, psychological support, medical assistance, and in some countries also provided some accommodation. Of course, at the beginning, everything can look ideal, but in 3 years, we now recognize that there are so many issues because countries cannot think that it's really short term. Rehabilitation and integration programs are really long term, but the main message, I would like to say that it's possible, because we met with many female returnees as well. We saw children, and especially children, they really reintegrate very fast. They go to school, and many children, they feel normal now. And of course, some children, they still need some psychological support. But the main message, I would like to say that the cases of Kazakhstan, Uzbekistan tell us that it's possible to reintegrate and to rehabilitate children and women. But in general, when it comes to the whole picture, about 40,000 people traveled to the Middle East to join terrorist groups, yeah? So the main reason why we have to worry is, I think, twofold. First of all, as Ms. Fionnuala said, there are children, thousands of children, I think 40,000, yeah? And then, of course, a humanitarian crisis is really, we should worry about their health, safety, about women and children. It's first reason. But second reason is international peace. All UN state members, they have shared responsibility for international peace. So the international community, all states should take actions to resolve this situation. And at the Bulan Institute, we analyzed all options. For example, at the beginning, almost all countries, they were reluctant to repatriate. And of course, Western countries, European countries also, they consider different options. So for example, ad hoc tribunal and triple citizenship, which was practiced widely, and transferring to Iraqi prisons. But the real situation is only low compliance solution is rehabilitation and reintegration. But the good thing is, I think from 2022, we have some positive movement, but it's a very small, because there are now, I think, regarding the third nationals, 10,000 women and children should be repatriated at the moment. And the case of male fighters, it's a completely different question. And I think now we don't have even discussion about this yet. No. Even no discussion. So I think why we have to worry is about the male fighters also. This is a huge issue, and it's very big threat to the international peace, because the northern Syria situation is very difficult, and they can flee. They can flee, and they can rejoin terrorist groups. And so that's why I think the countries should take responsibilities over their citizens, repatriate, and of course, male fighters should be brought to justice and should be repatriated, and at home they should be brought to justice at least. And what else? So I would like to say that I mentioned my book. So in my book, I analyzed the whole picture of the jihadism. So in this Soviet Bulan war, for example, 20,000 fighters were mobilized. And then after the withdrawal of Soviet army, there was no programs, for example, no disarmament. So that's why they were just left like this, and then they became nomadic. So that's why if we draw the parallel between these two cases, of course, we should take this situation very seriously. And now, regarding the current situation, when it comes to the rehabilitation and integration program, many countries, they fear that they will fail to rehabilitate and reintegrate them. I understand. I think from our observation and from our research, it's not easy task. It's not easy because it's very long term. Even 5 years, it's not enough. Maybe 10 years, I don't know. But at the beginning, for example, when we conducted interviews with the Uzbek experts, for example, from Kazakhstan, they were saying, for example, maybe 3 years, maybe 5 years. But now when 3 years passed, we understood that it's not enough. Maybe it's going to be long term. And of course, governments, countries, they need more financial resources, more human resources. But they, despite all these obstacles and challenges, the only low compliance solution at the moment is rehabilitation and reintegration. And of course, under the UN Security Council resolutions also, and under international norms, countries, they have state obligations to repatriate and to brought to justice if there is evidence about their crimes. But of course, regarding the children, they are victims. They should be brought first. And on the queue of repatriation, children are first, of course. So I will stop here, and then if there are questions, we will continue.
Yeah, many thanks indeed, Cholpon. I think it's a very important message indeed, because we know, and we've touched upon the fact that the reluctance of many states to repatriate has indeed to do with either fears that they might not be able to reintegrate individuals concerned, or that they might not be able to prosecute those who might need to be prosecuted. And I think the experience that you have witnessed is that it is, in fact, possible. It is not a short term, it is a long-term issue. It is going to take resources and time, absolutely. But I think your framing of the issue also from a peace building perspective is very relevant here, to say beyond the issues of jurisdiction and so on that might have to do with the connection between those individuals and the state of origin, if we want to ensure that this region is able also to transition to a peaceful situation. We can now allow these individuals to remain there. If we want to allow for accountability, for preventing individuals from rejoining, this, in any case, repatriation is the first step, and it is absolutely necessary. So thank you very much for your insight on this. And now I'd like to turn to Khalid, Koser. And Khalid, precisely, you have experience with the issue of extremism, countering extremism, prevention of extremism. And so maybe you can tell us a little more about precisely the work that the GCERF has been doing on this with children, among others, and what are the good practices, and what does your experience suggest in terms of how successful those initiatives are, and what are the challenges post-repatriation as well?
All in 10 minutes.
All in 10 minutes.
Thanks very much. Look, let me start by thanking and congratulating Cholpon for bringing us together and for flying this flag so strongly in Geneva. This is a topic that I think belongs in Geneva, and we're grateful to you for making sure that we continue to pay attention to the topic. I think it's also, by the way, a topic that belongs in a university like this. This is a topic that we need to discuss in an objective manner, in a safe environment where we can disagree with each other if necessary. And for me, that's what universities are about. And we're fellow professors, and I'm sure we agree on that. Cyprien, thank you for your excellent moderating so far. I won't say that if you cut me off short. And I want to spend a couple of moments on the Special Rapporteur. I've worked with several in my time, and I want to congratulate you personally, Special Rapporteur. In my understanding and knowledge of the UN system, Special Rapporteurs are not campaigners, they're not advocates, they're people who are brought in to try to shift the political needle. And as you yourself said, I think that's exactly what you have done. I think the political debate has shifted since you began your mandate. I think we've seen an evolution of the legal framework, I think largely under your guiding hand, so congratulations to you on that. I would be interested, if there's time, to think through with the Special Rapporteur and Cholpon what other factors, besides the excellent work of the mandate, have engendered this gradual shift in our approach to the topic of repatriation and reintegration. I think, for example, public perception has softened a little bit because of time. I think 5 years ago, you just wouldn't have been able to sell this in the UK. Perhaps now you can begin to slightly. Public perception has perhaps forgotten the issues or moved on. I think personally, the US has pushed this very strongly for whatever reason you might want to argue, good or bad. But certainly in my world, the US has decided that this is a critical priority, and many other states are following that lead. I think that's largely good news. And I think modestly, we, and Cholpon mentioned this, we at GSERF and others are beginning to demonstrate success. Yes, it's a challenge. Yes, there are things to fear, but this can be done. And I think if we can promote success stories and promote good practice, then that also helps the case. So it'd be interesting to reflect on what has evolved in the last 5 years, besides the mandate and its energy, that we arrive in a position where we have at least some potential and some hope. I wanted to spend a few words on GSERF, a couple of words on what we're doing at the moment, and then a couple of words about future plans, and then look forward to discussion. GSERF, the very clunkily named Global Community Engagement and Resilience Fund, based across the road, about 50 yards away. So, Special Rapporteur, next time you're in town, please do come and see us, and you're all, of course, welcome to come and see us. 3 hallmarks of GSERF that I think apply in particular to this topic we're discussing. Firstly, GSERF is a global fund, a little bit like Gavi and the other big global funds up the road. What that means is we are a grant-making organization. We're not an implementing agency. Our job is to collect money in a strategic manner, to pool that money, and then to distribute it strategically via grants. I think that's important for a couple of reasons in this specific context. One is the added value of a global fund is that to an extent it is depoliticized. It may be hard for, let's say, the Dutch government to invest money in returning Dutch citizens or returning citizens to anywhere in the world and focusing on their repatriation, their reintegration, their resocialization. Working through a neutral vehicle like a global fund sometimes depoliticizes the issue. A second reason why I think a global fund has added value in this area is the point that you made, Cholpon, in particular, that this is a long-term initiative. Even if you manage to repatriate people, the idea that you can reintegrate and resocialize them in a year is simply nonsensical. This is a labor-intensive and enormously expensive endeavor, and that's one of several other reasons why I think governments are reluctant. They know they will have to invest a large amount of money in a relatively small amount of people to to make this work. Again, the beauty of a global fund is it provides a funding mechanism to overcome some of those challenges. I think the other reason the global fund model might be worth just reflecting on is, to an extent, a global fund model is a reflection that we are dealing with an issue that is a global public good. The point of this funding is not that it's earmarked. It's not about the Dutch government giving us money to work on Dutch citizens. It's about the Dutch government giving money to a pooled fund which is spent strategically, whether that's returning Tunisians or Indonesians or people from the Kyrgyz Republic. And I think that's what we need to do, to move this away from directly pure state interests and to make a general understanding that if you want international security and peace and order, it is in all of our interest to make sure that these camps are eventually in an orderly fashion emptied and people are safely and in dignity returned home, especially given what the Special Rapporteur said about children and arbitrary detention and torture and all of those very important points. So first point, GSURF is a global fund. Second hallmark of GSURF, all of our funding goes to civil society. We are a fund that provides grants to local and locally registered non-governmental organisations. And we do this across the spectrum of preventing violent extremism, not just on this specific topic of FTFs and their return, but I think of all of the areas in which we work, this is the one where I have seen most governments understand that they need civil society in order to make this work. We work in other areas of preventing violent extremism where governments still labour under the illusion they can do this themselves. They don't need communities, they don't need civil society, they don't need all of that extra apparatus that comes with incorporating and consulting civil society. Most governments that I know that they can't do this without civil society. And I think that's one positive element that perhaps is emerging from this discussion. And I think the third element or hallmark of GSURF and the work we do, as I've mentioned, is a very specific mandate on preventing violent extremism. And we can debate what that means, and it's still, I think, a contested term, but I think it's relevant to this topic in at least three ways. One is, and I agree with the Special Rapporteur that we shouldn't overplay the security aspects of this, but one is, I think, Cholpon, you mentioned it, a small risk that there are some people within these camps who may become re-radicalized, who may join other terrorist groups should they be able to move. There is a possibility. I think it would be foolish to ignore that possibility. A second link to preventing violent extremism, and I think we found this around the world, is that if you can develop the appropriate circumstances, the voices of people who have sometimes made the error of going to Syria and Iraq or joining terrorist groups in other contexts, their voices are more powerful than anybody else's in convincing others not to do the same. So giving a platform or a media possibility to some people who have been victims, who have returned, we find to be important. And the third link, I think, preventing violent extremism is this, I would say, largely myth. And I think the Special Rapporteur hinted at this. I don't think she used the word myth. The myth or the misperception that we shouldn't be returning these people because we are risking importing potential terrorists. We are risking importing a new influence on radicalization. Our evidence at GSURF is that that is not the case. And I'll give you a very interesting anecdote that I think provides a twist on this. We worked with a small group of women, returnees in the Western Balkans, who were finding it, of course, very hard to reintegrate in their communities because of suspicions. You've just come back from Syria and Iraq, your husband was a terrorist, we're concerned that you might become radicalized, we're concerned that you're a potential terrorist, that you're spreading your poison within our communities, and so on. Marginalized, children not allowed to go to school, nowhere near getting a job, nowhere near becoming part of a community and a religious institution, and all of the things that are central to being part of communities. Our research suggested, after in-depth discussion with these women, that far from them coming back as a threat, there was a risk that they would become radicalized because of their marginalization in the communities to which they were returning. So you weren't returning people who were a threat, but you were effectively creating a threat around the way that you treated them. And I think that's a very interesting twist on this notion that somehow these returnees are a risk. They're a risk, but not for the reasons that I think often we think. So that largely is what GSURF is, a global fund, grants to civil society, working largely on preventing violent extremism. A couple of words quickly on the work that we're doing on this specific topic, and it's one of many topics on which we work. I mean, firstly, I want to just note that, yes, we are working in particular in the Western Balkans on helping to reintegrate within their communities returnees, mainly women and children at the moment, men perhaps somewhere further down the line. We also work in a slightly different context on, for example, reintegrating demobilized child soldiers in places like Somalia and Mali and so on. And I'm quite an advocate for not treating any area of public policy in isolation, but trying to learn what we can from other associated areas. I'm not suggesting there is a legal comparison between demobilized child soldiers from Al-Shabaab in Somalia and returning children from the camps, but surely there are lessons to be learned. And similarly, I think lessons to be learned from the wider field of refugee repatriation as well. It seems to me this is a very specific group of people with very specific legal and other challenges, but that doesn't mean we shouldn't be trying to feed in what we can learn from other areas, recognizing the distinction as we go. Most of our work in this area at the moment in the Western Balkans, and I think three main focuses for our work, and my colleagues are much more expert than me on what we do. One piece of work that we do is clearly working with governments to support the development of national strategies, to support the development of legal frameworks, of course, often working hand in hand with the Special Rapporteur on that. A second strand of the work that we are doing is working with effectively frontline workers, whether that is trauma providers or doctors or nurses or teachers or religious leaders. Quite a lot of work with the media, because the way that the media portrays this, I think, is immensely important in terms of how communities receive or don't receive back people from their communities, and also some work with the private sector. Because surprise, surprise, local business people are not particularly keen to employ people they perceive as possible terrorists. What our research suggests is if you do employ them, they will be immensely loyal. These are perhaps the best people you can employ if you want to look for an employee within your community. So working with the community agents who are responsible, are the gatekeepers for the reintegration of these people once they return. And the third strand, government frontline workers, the third strand, of course, working as far as we can with the returnees themselves, and in particular the parents of children, because working with the parents to help to overcome some of their concerns, to help them understand that putting their children back into school is a positive thing. All of these things we think is very important. And lots of stuff on our website, and I can share that with you. In terms of the future, again, of this one strand of much larger work that GSURF does, geographical extensions. Cholpon knows that we are hoping soon to work in the Kyrgyz Republic, and I think Special Rapporteur, you and I have discussed Kazakhstan in the past. Indonesia, we think coming soon. We've just had an agreement from the government of Iraq to support the government of Iraq in this procedure, and we've heard there's 30,000 or so. This is the really big population, the Iraqis, so I think interesting there. That's the geographical extension. I think the kind of more challenging extension is, if you like, an extension across the cycle. And we are currently in discussion with various donors, I won't go into detail at the moment, about whether and how we might support civil society in the camps themselves to try to help prepare people in the pre-departure phase before they go back. And again, there's some parallel towards refugee repatriation, where the process should start before people leave camps in the first place. And I think some really interesting thought about whether and how to do that, what the ethical dilemmas are, which communities you work with, how you would get cover from the government, which, as you said, is a pretty politically fluid environment. But I think in principle, to provide citizenship training and other support for people before they even make that trip home would in principle be an important thing to do that we're thinking about. Thank you.
Yeah, thank you very much, Khalid. And indeed, there is a number of very interesting points you made. I think one of them is the need to involve beyond the government, also civil society, absolutely, and also the private sector. And I think that's a point that we probably don't hear quite enough. So that would be interesting, and maybe we'll get, I think we have already from participants online some questions on this. And then another point that you made, and general point that maybe is something we want to discuss as well, is on the narrative and the way we approach the issue, and the risk of overplaying the security aspect of it, one way or the other. And the risk that by overplaying the security aspect, we might contribute to further marginalization. And from your work on extremism, and for experts here who are joining us with knowledge on this, we know that marginalization is a big factor in so-called radicalization as well. So I think that's also a very interesting point. And finally, maybe that's again something, Cholpon, you might want to speak to as well, on the different stages of repatriation when it happens and the pre-departure phase. I think is also a step that we often don't think of quite enough. So I think that those might be points we might want to discuss. We will now turn, and we have about half an hour left for the question and answers. So for our participants in the room, feel free to think of our questions. We will take a few questions at a time and then let the panel answer it. And then for our participants online, feel free to write it in the chat in the Q&A function, and I will also try and ask questions on your behalf. And as we let the participants think of the questions and who they want to direct with and what aspects of what we've discussed so far they want to ask about, I think maybe I would start and take advantage of my privilege as moderator to ask you two questions, special rapporteur, on one of them on the legal aspects. And I know that we have a number of colleagues who work on the legal dimensions of it and some students as well. And especially on the question of jurisdiction, because we've talked about the various human rights violations that are occurring in the camps or in the prison. I think it's a secret for nobody that they are indeed violations of the prohibition of torture and human treatment and so on, and forced appearances and so on. But one of the issues has been what is the connection between the foreign nationals in northeast Syria and the state of origin? And the state of origins, and we've mentioned it, sometimes have stripped the citizenship of the nationality to remove this little connection that existed. But sometimes they also just argue that if it's not within the territory, it's within their effective control, it's not their responsibility. And you've argued and you've said, as soon as there is control, and in this case, there is control over the lives of these individuals, and whatever the states are doing back home, it is impacting the individuals in those camps. So maybe comment on this, and especially because you mentioned the ECHR case, and we know that the ECHR, among others, said a lot of things, but did not quite explicitly say, yes, there is jurisdiction. And for all our human rights students who might be here, we know that jurisdiction is always an issue in this area and could be potentially a controversial one. And then the second question, that is also a question that we received from colleagues online on the individuals that cannot be returned to their country of origin because of non-refoulement not concerned. And what is your approach on this, again, from a legal and also policy perspective?
Sure. No, thank you. And just thanks to my co-panelists, and I think some really important reflections on the post and the importance of how we both think about the long term and but also the kind of the range of interventions at different levels that are required to address successful repatriation. So on the question of control, I mean, my team and I, and led by my senior legal advisor, we've taken the view of a functional approach to control. And that means, to use the simple analogy, that if the state of nationality is affecting control over, in this case, whether a person can enter or exit. So you are essentially the gatekeeper is not the SDF. The gatekeeper is in fact the country of origin, which is not enabling return. They have a functional control over the lives of those within it. I think we would also say, and certainly this was in our ECHR submissions, in the Begum submission, we also took note of the difference in treatment within the camp of different persons based on the position of the government of nationality. Some people get phones, some people do not. That is not happening by accident. It's happening because the state of nationality is playing a significant role in the regime that is addressing, that is actually regulating the day-to-day life of the individual. We would also say that the choices that states have made to bring some people home and others not, again, is a degree of control, absolute control over the fate of a person's life. Because again, and it should be said, we would say there's a great deal of arbitrariness being exercised in that context where, for example, the criteria by whom individuals are selected for return in itself has a high degree of discretion and arbitrariness by the state. It often doesn't correspond, for example, in a country that shall remain nameless. We know that persons who were returned had relationships with ministers and government. That's a criteria to get someone home. We wouldn't suggest it's a human rights compliant criteria to get someone home, but we can see in this question of So functional control. Now, in the context of the ECHR, I think my legal advisor and I would say they dodged the ball. So we wrote a just security article on that very point. But I don't think we lost the argument on control. I think the court was too nervous to make the decision where the facts and the evidence lead us to. It's a different kind of proposition. What the court did say, though, in the ECHR case, which is very important, is that it tried to get at this question of arbitrariness by saying that states had an obligation to put in place a criteria that was human convention compliant on the determinations of whether they should or they shouldn't return someone home. So I do think that speaks to the recognition of the court of the degree of control that a state has. So they're not using the words effective control, or they're not talking about function control, because states are a little allergic to control these days. And the court is acutely sensitive to that. But they did speak to this question of how you structure it. Actually, to my mind and Anne's mind, I think I'm speaking for both of us, is that it really goes to this point about it's an implicit acknowledgement of a degree of control, precisely because it's recognizing the state can do some things that it's not doing. On your second question around nationality stripping, I mean, again, I would say we have seen a significant practice of nationality stripping. One of the things that concerns us is that in the mandate is what we're seeing is enormous arbitrariness in this process. So the first point is that many persons who've been citizenship stripped are citizens who cannot lose their second nationality. So those are individuals who, it's not that there's citizenship stripping across the board, there's citizenship stripping for people whose second nationality, by definition under that country's law, can't be lost. So that, again, creates a vertical geometry of who's being stripped and who isn't. And it's, I should say, highly raced in some ways, and highly, it has a really, I think, not just an arbitrariness to it, but it creates these hierarchies of rights of citizens who have first-class citizenship rights and citizens who have second-class citizen rights because they happen to have a second nationality that they can't get rid of. The second point about citizenship stripping is that many of those in the camps who have been citizenship stripped don't know. There's been no communication to them, to their families, there's no process. Now, to be clear, states do have the right to strip citizens strip citizenship, but the legal regulation of that under international law makes clear it's a highly exceptional, and a person should never be left stateless, and that there is a right to have a right of appeal or some kind of participation in the process. So to be clear, no one is participating in any process, no one has any rights of appeal, and in some cases they don't even know. What does this mean? That we're left with a very large group of people, the numbers of which we're not exactly sure of, who have no citizenship, or their second citizenship, as in the case of Shamima Begum, is actually ineffective, because Bangladesh has said clearly we don't accept that she is, in fact, a citizen of this country, so she is stateless. And what do we need to address this? Well, I think what we need is as the mandate is called, on a moratorium on citizenship stripping in a context of mass arbitrary detention. That's the first thing we need. The second thing we need, as I think we're going to get through the European Court of Human Rights, because there's a whole bunch of cases just heading their way, is actually states' requirement, a finding that this form of citizenship stripping is non-convention compliant, it's arbitrary, and therefore inconsistent with the principle of legality. And I do think that states have to think about, to go to Khalid's point about security. I mean, when you sever a person's relationship with the state and you throw them out into the desert of the dangers that the likely implications on security are extremely high, because the despair of a person who has no citizenship is a despair that in many ways we know are often the trigger. We know, for example, from the UNDP study on pathways to extremism in Africa, that 71% of persons experience a push to violence or violent extremism as a result of a human rights violation. Arbitrary deprivation of citizenship is a human rights violation. So that would be.
Yeah. And how about individuals who have nationality but cannot be returned?
So on non-refoulement, I think this is a very difficult question, which in fact, as we've seen, there's been very little engagement with. I think the mandate would have a number of, one is that we have to, again, and this will require a holistic solution. And for example, if we think of the global coalition on ISIS, we see very little willingness to deal with holistic solutions, frankly. But this one will require a holistic solution. One version of that holistic solution is that third country states will accept persons who are at genuine fear of persecution and cannot be returned. I wouldn't be betting my house on it, right? I mean, we see the difficulties, but I think nonetheless states of principle should be making, and we should be making the case that states have an interest in protecting individuals, highly vulnerable individuals, including children, and offering them refuge, as we've always done, by persons facing persecution. Not everybody who faces persecution is an attractive proposition. That has been true historically. It remains true today. We don't get to pick and choose who we give the privilege of the agreement of non-refoulement to. So that's the first. The second is, frankly, we're going to need a bespoke solution with the states, the territorial states engaged in this question. That's complicated. But I do not think that we will get a solution to this problem unless we grapple with some of the issues that are currently tied up in internal armed conflict, but also in addressing the states of nationality in the territorial states. Because if you're going to need people not to be in a camp and to stay in a territory, there has to be an agreement that they're going to stay there. So that's what we have to do.
No, thank you very much. And I think on third states, relocation to third states is an interesting example, because here in Switzerland, we had some reports recently of the US approaching the Swiss government on Guantanamo, on relocating detainees in Guantanamo to Switzerland who cannot be sent back to their country of origin. And it has taken years for the United States to find solutions for these individuals. So indeed, we can imagine that it would be complex in this case as well. Even though the tables have turned, and now it's the Americans in the context of foreigners in northeast Syria who are pushing for it, and the Europeans who are reluctant about it. I turn to the room, the audience in the room. Is there any question? We have some microphones. So we have 2 questions here at the front.
Hello. Thank you so much for the time and the opportunity. My name is Abraham, and I represent an NGO here in Geneva in Vienna. I have a lot of things to say, but let me be very brief. Thank you so much for Madam Rapporteur for the report. It's comprehensive, concise, to the point. To Dr. Khalid, Koser also. And then the third person, the name is very difficult to pronounce. Sorry. Please forgive me. I came across the situation of we discussing here repatriating foreign fighters with my colleagues from the HD and the European Institution for Peace. But I still have a lot of, some sort of dilemma. And some of them is, how do we identify that this is a fighter and then they need to be repatriated or not? One, because my colleagues who work there, sometimes people give fake nationalities, and the identity to identify someone, it will be easier in the Western world, in the developed system, than if you are in Daraa, Deir Zur, Hasaka, those refugee camps. What do you do to curtail, those kind of problem, the hindrances that you face? And then you using the word arbitrary detention. How do you know? You see, the word arbitrary, I'm not too comfortable. I'm not I don't want to say confident. I'm not too, less to mortah. I'm not too happy with it. Right. One of the issues Ustaz Khalid mentioned is the dialogue, you see, because most of these conflict problem comes with sectarian, problem. Like if it is proven that this person is from this party, like let's put it this way, Shia, the Sunni, even if we know that this person is from here, we're not going to accept the person in this society.
Yeah.
So issues like that, how do you do that? Thank you
very much for your question. Yeah, sure.
So the identification process is very important, but majority of the citizens, they have nationalities, citizenship, and then the countries, home countries, they have already the list of people. So they identified already a list of people who are in the camps, majority of countries, majority. For example, if one country wants to repatriate, so special services, they have all information who went to Syria. And then they contact family members. So they double check, because family members, they usually approach law enforcement agencies asking for help. And then they double check with they compare information. And for example, in the case of Central Asian countries, Kazakhstan, Uzbekistan, Kyrgyzstan, they closely work with family members. And then family members, they are in contact with those who are in camps. They spoke with by WhatsApp, Telegram, and then the women who are in camps, they help actually law enforcement agencies identify their citizens. So there is no issue to identify, and whenever there is a list, of course, and then if the country decides to repatriate, they send the task force or delegation, whatever, they arrive to the camp and they meet in person these women and children to discuss. Sometimes citizens, they refuse to be repatriated, but it's very little number. And then regarding the crimes, evidence, of course, it's a very difficult issue, but anyway, countries are also dealing with this. For example, Kazakhstan repatriated 37 men, and for them, Kazakhstan found evidences, photos, videos, because ISIS fighters themselves, they were very active on social media. They were posting photos, videos, and proving their crimes. And for example, one Kazakh fighter, there was a photo or video, I think. He was putting his posting photo with the even beheaded body, So in the court hearings, there were really many evidence about their crimes. So that's why it depends on the work of special services. And some countries, they really observe it, the social media posts, and they were documenting everything. But maybe some countries didn't do that. Maybe they don't have evidence, I don't know. But when it comes to male fighters, I think many countries, they have already the evidence. They might have. But regarding the women, I would like to say that majority of women, especially our focus countries, Central Asian countries, many women, they stayed at home, really, with children. They returned with 4, 5 children, 3 children, and they were just taking care of children. So that's why Uzbekistan took, for example, hands-off approach regarding women, because they understood that all Uzbek women, many of them, they just stayed at home, taking care of children. And in Kazakhstan, only 12 women, they were arrested because Kazakh authorities, they found evidences about their crimes. What kind of crimes? It's propaganda and recruitment.
Thank you very much, Cholpon. And Fionnuala, you want to respond to that?
Yeah, I was going to make a distinction. So I think on the question of identity, we do have some gaps, meaning I would say 2 things. What the mandate has said publicly, we've communicated there was a mass biometric data collection exercise at these camps over 2 years ago. So it is on the basis of that, which of course was a non-consenting biometric data collection exercise by a non-state actor. It is clear that there is there is evidence and information on the identity of the individuals We're also aware that governments have information about their nationals. But I think I would say from the mandate's experience, when we engage with many countries as we do about repatriation, they tend to say a lot about how difficult it is to identify their nationals, which frankly is usually a strategy to delay bringing their nationals home. And I think we've seen, and Kazakhstan is a really good example, Uzbekistan is another, where actually when states want to do, for example, if there's a question, DNA testing is actually very straightforward and done mobilely, and it's not very complicated to do in these contexts now. So the issue is not can individuals be identified, it's do states actually want to identify individuals and engage with them and return them. The second thing I would say, I think there is no doubt that this is a situation of arbitrary detention. This is a non-state actor holding individuals who have had no process of law. So I don't know in general that we think of non-state actors as having the lawful right to detain anybody, and certainly not with any process of law. And we generally don't detain women and children for simply having babies or being born in a particular place. So I think the United Nations human rights bodies have been very clear that this is a situation of arbitrary detention. There are some caveats. If one is in a situation of armed conflict, individuals who are fighters can be held in particular ways under the relevant laws of war application. But again, that requires a determination. There has been no determination. And I would just say one thing about fighters, and one of the things we've learned from places of large-scale arbitrary detention of men, Guantanamo might be an example, is that large groups of people get swept up, and all of them in the beginning are called terrorists. And then it turns out that you end up letting lots of them go. And the reason is because you've determined that many of them should never have been there, that they were caught up for different reasons, or that they will be returned, whether it's under an amnesty agreement or a plea deal agreement. But so none of those processes apply here, meaning we have taken a group of men who remain imprisoned with no determination or distinguishing being made between categories of responsibility and non-categories of responsibility. And for the victims of terrorism, it's important that we actually start to do the work of distinguishing who's done what. And we've consistently said member states have an obligation to prosecute where they have evidence. But if you don't bring them home, you're not going to prosecute them, because generally in international law and state practice, we don't let non-state actors prosecute individuals from countries that are not their countries of nationality. So it would also seem to me that states have little interest in prosecution if they're not prepared to bring their nationals home.
Thank you very much indeed. Question here.
Thank you so much, and thank you to all panelists for your very valuable insights so far. I think the issue of repatriation of foreign fighters highlights quite well the interrelatedness between counterterrorism and transitional justice as a whole. So I wanted to ask whether the two fields, at least in your opinion, have some other links as well, because the way I see it, a solid counterterrorism strategy can play a major role in very fragile post-conflict societies, in fostering and protecting peace and security. But at the same time, I think there is an argument to be made that counterterrorism measures that are too intrusive, that completely disregard the rule of law and human rights, such as the detainment camps we've discussed today, they foster civic distrust instead of civic trust. They do not promote reconciliation, and they arguably steer this very fragile society away from democratization as a whole. So I guess I want to pick your brain a little bit on how counterterrorism measures and counterterrorism as a whole fit into this wider narrative of transitional justice, and whether the current approach to counterterrorism on the international, regional, and national level can actually be conducive to successful transitional justice process around the world. Thank you.
Yeah, thank you very much. And Khalid, I think you have to leave us in a few minutes. So do you want to respond? Also, there was another question for you online on especially the relationship between and how in practice governments work with NGOs and the private sector maybe as well. So if you want to respond to this or maybe this last question.
Yeah, and I'll slowly pack, but I think we're finishing fairly soon. But anyway, a great question on counterterrorism more broadly. We have the special rapporteur with us, but 3 observations on counterterrorism. Firstly, it is reactive, not proactive. By definition, you are countering something that's taking place. And the point of preventing violent extremism is to accompany that process by trying to address the drivers and the root causes before it takes place. It seems intuitively obvious. Let's vaccinate people, to use the health analogy, rather than waiting until they have a disease to try to cure it. It's the kind of health analogy. I mean, very clear. Secondly, absolutely clear that however counterterrorism is undertaken in whichever country, with whatever will and whatever motivation, there are almost always unintended consequences. And those may, at worst, generate the conditions that radicalize further people. So the risk is you have a negative impact of counterterrorism by making people feel that they are being picked upon or marginalized or discriminated against or unfairly targeted. You risk them becoming radicalized as a result of counterterrorism. And the third thing, clearly, and that's why we set up this fund, is that counterterrorism is an enormously cost-ineffective way of dealing with this. You know, the cost of a drone to shoot a terrorist in Somalia is a lot of money. Train some religious leaders and provide some education to young people and give them a better alternative. That's a pretty cheap way of, I think, reaching a far larger number of people. So it's clear to me, you know, I think counterterrorism as a policy will continue, but I think it needs to be accompanied by other more development-oriented processes.
Thank you very much. Fionnuala, you want to respond?
No, I was going to concur with the view that the fundamental best insulation against violence, including terrorism, is addressing the conditions conducive. These are generally structural. They are, and they're very unsexy to fix. Nobody wants to do that work. What they want is like a bright, shiny object that's going to, like a drone, that they think is going to fix the problem. And so we've seen a systemic underinvestment in and I don't think we should, I mean, the mandate doesn't use the language of preventing and countering. We talk about just doing good governance. Sometimes it's important to use just those words, because the minute you say extremism, you've called a community extremist by virtue of being in a place. And I grew up in one of those places. So I think the costs of kind of communities being put into baskets. And so I think we need very basic things. We need good governance. We need rule of law. We need security sector oversight. We need sustainable development. We need the acknowledgement of climate affected communities being fundamentally challenged in addressing their needs, and therefore violence becomes a logical extension of what you would do. I think the other challenge I see is we don't see much good counterterrorism out there, frankly. There very little. If you ask me, and the mandate reviews a lot of strategies for a lot of governments, and we see models of kinetic counterterrorism. So let's just talk about Afghanistan. If we were ever to say, does it work? Well, clearly it didn't work so well. The Sahel is another great example of investment in kinetic counterterrorism, which produced security-dependent states without any security sector reform, which resulted in the security sector decided that it didn't need any of the rule of law stuff that was a little irritating, and they could just get rid of the democratic government in at least 2 countries and do it with some help from some other actors along the way. So I think the point is that for the mandate, there's this enormously important question, is really the M&E question, the question that Khalid asked, which is, does any of this actually work? Really? Does any of it actually work? Does the places where you're spending your money do more than simply produce and reproduce the cycles of violence? So I think we would be quite skeptical. The mandate's report to the General Assembly last year was on this intersection between peace and counterterrorism. And my observation is that counterterrorism is eating up peace and security. We're seeing less and less of conflict management and more of kinetic counterterrorism. And it's pretty clear to me that kinetic counterterrorism doesn't work. So therefore, we're getting more entrenched conflicts and cycles of violence that are really difficult to undo. But
Thank you very much. And Khalid, you want to
just quickly, the question about the private sector. I mean, one thing I think governments recognise is that the private sector, you can criticise the private sector, but it's good at one thing, and that's creating jobs. And I think jobs are critical. We found in the communities we're supporting around the world that unemployment is one of the factors that drives people to make, I think, the wrong decision. But to illustrate the Special Rapporteur's point about these being unsexy, but also complicated things to do, let me just give you an anecdote from one of the many surveys we've done. This is in one community in Nigeria, and a long survey amongst people we were working with. One question somewhere in the top of the survey, what are the main reasons you would consider joining a terrorist group? Top result, lack of work, lack of employment, unemployment. Fine. So a good, well-trained policy analyst therefore give them jobs, and you resolved it. Later down in the survey, where in your community are you most likely to be recruited? Answer, the workplace. Right? So it's not just a job, it's the right job, in the right place, in the right circumstances, with dignity and all of those sorts of things. So yes, preventing violent extremism is A, unsexy, and B, very difficult to do.
I mean, this I agree with you. The one place I would maybe slightly disagree is I think governments have been prepared to spend more money, I see it on preventing and countering violent extremism as a banner, and less prepared to spend money in things that are just called development. Yeah. And so I think we are seeing a tension point where, this is just it speaks to the complexity of where governments want to spend their money and what banners they use. And I think the cost of that is that we're not doing very effective work on addressing the conditions that produce violence.
Thank you very much. And unfortunately, we have to wrap up. But maybe if I can ask you, Special Rapporteur, a last question with almost a yes or no answer, because the co-sponsor to this event is the International Law Department here at the Graduate Institute. And we know that courts have played a particular role. Has law proved powerful on this issue, or will it be powerful? And what's your take as a lawyer at the end of the day?
Law is extremely powerful in counterterrorism. We have 20 years of Security Council resolutions, Chapter 7 resolutions on terrorism that have moved us to legislating terrorism through the Security Council. We have 2 decades of soft law that is effectively hard because states prefer the soft law that they get to make without a whole range of diverse actors or other states in the room. So no, law is incredibly important here, but law has been playing an extraordinarily destructive role in producing and reproducing the cycles and the kind of path dependencies that are in effect undermining our stated reasons. So it's not an absence of law that's the problem here. The problem is the kind of law that's being produced to address this problem, and who and where in the system that law is being produced.
Thank you so much, and duly noted by our international law student in the room online. Thank you very much, Fionnuala, Cholpon, Khalid, for this event. Thank you to the participants in person and online. Thank you to our sponsors, the Bulan Institute for Peace Innovations and the Graduate Institute International Law Department. This event is recorded and will be online. And so we wish you a good day, and hopefully that was good food for thoughts for all of you on this topic. Thank you very much. Have a good day.